was occurring during voir dire. The trial court improperly discharged 13 prospective jurors over defence objection based solely on jury questionnaire answers, showing that although they opposed the death penalty, they could nevertheless consider death as an option. From the beginning of voir dire, it became clear that the trial court and defence counsel had very different views as to the propriety of discharging prospective jurors simply because they were opposed to the death penalty. To its credit, the trial court made quite clear its view that only those who supported the death penalty could qualify as jurors in a capital case. We'll excuse juror 6033 because the court's opinion is that she can't. If you don't support the death penalty, you cannot be death qualified. As the rest of voir dire would show, this was no mere slip of the tongue, but reflected the court's considered view. The court could not have been clearer. Under Wainwright v. Witt, if you are opposed to the death penalty, you are not qualified to serve as a trial juror in this kind of case. Again and again, the court returned to this central premise. If a juror was opposed to the death penalty, the juror could not serve. I'm going to excuse juror 24095 because he opposes the death penalty. I'm going to excuse juror number 29280 because this juror is opposed to the death penalty and fails Wainwright v. Witt. 29280 is excused. So if you don't want to stipulate to the excusal of juror 4841, fine. But if they oppose the death penalty, they are not qualified under Wainwright v. Witt. Juror 4567 opposes the death penalty, so he wouldn't qualify. Juror 962 opposes the death penalty, she could never serve anyway. Juror 6264 opposes the death penalty, so he wouldn't qualify under Wainwright v. Witt. Juror 630 opposes the death penalty anyway, so he fails Wainwright v. Witt. Defence counsel did not share this view. To the contrary, as his objections to the court's discharge of jurors mounted, counsel put on the record his very different view of the court's power to discharge jurors. Strongly opposed to the death penalty doesn't mean that he can't implement it in the appropriate circumstance. Obviously, I believe that opposition to the death penalty should not be a for-cause challenge. The court has ruled on it. I'm not going to continue to raise it each time, although I want the record to reflect that I am submitting on the court's previous rulings. The essence of this disagreement between the court and defence counsel was aptly illustrated by the following interchange. Mr. Gagaros: the gentleman who said he was opposed, you can be opposed to the death penalty. There's plenty of people that are opposed to it, yet it's the law of the land. The court replies, under Wainwright v. Witt, if you are opposed to the death penalty, you are not qualified to serve as a trial juror in this kind of a case. Mr. Gagaros replies, if you are opposed and won't carry it out, if you are opposed, yet you will carry it out, you can be intellectually opposed to the death penalty, yet if you will carry it out, you qualify. Indeed, at one point, defence counsel complained that we have now lost some 20-odd people, losing people solely because of their opposition to the death penalty. The court responded, well, that's the law in California. This is not the law in California or anywhere else. The trial court here discharged juror after juror simply because they stated in their written questionnaire that they were opposed to the death penalty. Every one of these prospective jurors stated in the questionnaire that despite their opposition to the death penalty, they would consider death as an option, and not a single one of these jurors was ever even questioned about their views. Instead, these jurors were summarily discharged. Defence counsel objected to every one of these discharges. During these objections, there were at least two prosecutors sitting at counsel table for the state. At no point during the trial's court exchanges with defence counsel did either prosecutor say anything. The state's attorneys did nothing and said nothing to correct the trial court's view. Instead, they simply took advantage of the rulings to try their case to a jury selected in this way. This strategy of silence worked. Of the 12 jurors selected to try the case, 11 were in favour of the death penalty, while the lone remaining juror was okay with the death penalty if warranted. Of the 6 alternates selected, all 6 supported the death penalty. And more importantly, for purposes of this argument, numerous jurors who were completely qualified to sit as jurors were summarily discharged from jury service without voir dire. As discussed further, a new penalty phase is required. More than 40 years ago, the Supreme Court recognised that a state may not entrust the determination of whether a man should live or die to a tribunal organised to return a verdict of death. Only 5 years ago, the court reiterated that a death sentence could not stand where the systematic removal of those in the voir dire opposed to the death penalty had led to a jury uncommonly willing to condemn a man to die. But that is exactly what happened here. As a matter of federal constitutional law, the trial court's clearly stated view that if you don't support the death penalty, you cannot be death qualified is unquestionably wrong. Reversal of the penalty phase is required.